I'm Ben Meiselas from the MeidasTouch Network. Judge Tanya Chutkan, the federal judge in Washington, D.C., just may have made the most important ruling yet in the criminal prosecution of Donald Trump in the Washington, D.C. case being prosecuted by Special Counsel Jack Smith for Donald Trump's attempt to overthrow the results of the 2020 election. On its face, the order seems to be fairly limited in nature. I mean, it's not based on a motion to dismiss. It doesn't seem to be as powerful as a order setting forth a trial date. What it does is it allowed Special Counsel Jack Smith to file under seal partially part of a motion where Special Counsel Jack Smith is filing for a limited gag order against Donald Trump. Donald Trump wanted the entire gag order filing to be made public so that the identities of witnesses that Special Counsel Jack Smith is seeking to protect, who Donald Trump is trying to threaten, Trump wanted those names released publicly, and so actually opposed Special Counsel Jack Smith's attempt to request that all of the names and identities of individuals who have received threats thus far be under seal. And here, Judge Tanya Chutkan made a very surgical ruling, and Judge Chutkan said, Special Counsel Jack Smith's limited sealing request is granted, specifically as it relates to the name and identities and communications received by witnesses who have been threatened as a result of extrajudicial statements, out-of-court statements like Trump makes on social media, who have been threatened as a result of those statements so that they don't get threatened again. Again, Trump wanted those names to be made public. So Special Counsel Jack Smith, shortly after this order by Judge Tanya Chutkan, filed this motion for a limited gag order requesting two things. Number one, that the court enter a limited gag order as it relates to Donald Trump's threats on the court, on prosecutors, on the District of Columbia, and on witnesses. And two, Special Counsel Jack Smith says if Donald Trump is going to engage in a poll or survey of the district to try to support a motion to change venue, which, by the way, would be done very belatedly, notice is given to the court so that that survey and poll is not used as a way to threaten the veneer. The jury pulls the veneer. And so that's what Jack Smith ultimately filed. But this order really shows you what Judge Tanya Chutkan is dealing with as well. And one of the things we've learned from these filings is that individuals have already been arrested who have threatened Judge Tanya Chutkan, who have threatened the court staff, in addition to all of these other witnesses who are important to this case, as well as the threats that are being made to Jack Smith and the threats that are being made to Jack Smith's team. See, that's stochastic terrorism right there. We talk about that a lot here on the MeidasTouch Network. You know, when Donald Trump makes these posts on his social media platform, his intended effect, and Jack Smith says this, and Judge Cannon, I think, is recognizing this, the intended effect is not just to show how deranged Donald Trump is. He is giving the totality of his messages are a call to action, a call of violence against the people who are targeted. Donald Trump is telling his radicalized base of MAGA, some who are incredibly violent, to do and engage in conduct like they did on January 6th. And Jack Smith's very clear. Jack Smith says this is what Trump is intending to do. And let's take a look at Judge Chutkan's order here, because this order has taken, I think, the case into a new phase. And this is the phase where Jack Smith, and this is what we've been waiting for, Jack Smith and a court to say, you know what, we're done. Enough here. This is not acceptable conduct, and enough babying this fascist, enough babying this treasonous traitor criminal, enough. Here's what Judge Chutkan ruled. She says, the government requested leave to file a motion under partial seal, specifically to file an unredacted version of that motion under seal and to file a redacted version on the public docket. That has since been filed. On the public docket, you see threats that Trump's made, but the people who he's threatening, their names, their identities are redacted. The judge, because of Judge Chutkan's order, and Donald Trump wanted all of that to be made public. Judge Chutkan says, as set forth below, the government has carried its burden of justifying the limited redactions it proposes. The court will grant its request. And the analysis that Judge Chutkan conducts is she balances the various factors for filing something under seal. Confidentially, the parties can see it, but not the public. And she weighs that against the First Amendment issues here. And she goes, there's not a First Amendment right to threaten and attack witnesses and the court and prosecutors in a criminal case. That doesn't exist. And so stop weaponizing the First Amendment as saying, oh, well, the First Amendment allows us to do whatever we want. You can't threaten witnesses, threaten judges, threaten the community. Here are the factors that Judge Chutkan balanced. The need for public access to the documents at issue. And Judge Chutkan says, look, the public can have access to the documents, but the name of the target being threatened, that doesn't aid the public in any way. It aids the party trying to threaten the individual's name. So we're going to redact the party's names. 2, the extent of the previous public access to the document. These documents were not public before, so putting the names of people who received threats by Donald Trump, making those public so they receive more threats is not something the court wants to do. By the way, that's something Donald Trump argued that he wanted to do. 3, the fact that someone has objected to disclosure. Here, the government objected to disclosure for the reasons that I'm discussing, to protect the identities of people who are being threatened and having their lives threatened. The strength of any property and privacy interests asserted. There is a major privacy interest of those who are being threatened to be threatened again. And if those names are made public or those people are called out in open court, they will get threatened again. 5, the possibility of prejudice to those opposing the disclosure. And Donald Trump's opposing the disclosure. And the court said, there is no prejudice. It's not prejudice to you that you want to threaten these people more. And 6, the purpose for which the documents were introduced during the judicial proceedings, and they're being introduced to ensure that no more threats occur to these people. And by the way, go back and watch the other video that we've done. We've done a few videos on Jack Smith puts forward all of these messages when Donald Trump's threatening all of these witnesses and all of these people. It's horrific, horrific conduct. Going back to the motion, it says here the government seeks leave to file a substantive motion to limit Trump's extrajudicial statements and threats. The names and other identifying information of certain individuals whom it asserts defendant has targeted with inflammatory public statements and who were subsequently subjected to threats and harassment. That's what Jack Smith wants to protect and keep those names confidential. And 2, excerpts from witness interview transcripts describing the threats and harassment they received. The latter category of redactions is from materials designated sensitive by the existing protective order between the parties. Nonetheless, Donald Trump was objecting to that and wanted all of that made public. In its motion, the government seeks to establish that defendant has publicly criticized his perceived adversaries and is aware that his criticism has led to their harassment. The proposition does not turn on either the identities of the specific individuals whom the government cites as examples or the broader transcript excerpts of witness interviews that the government's motion summarizes without redaction. Accordingly, the redactions will not significantly affect the public's ability to understand the basis for the motion or the court's eventual decision on it, which reduces the weight of this factor. You see how diligently the court is analyzing it here. And then finally, the court talks about the First Amendment issues and says Donald Trump contends that it is a First Amendment right of public access to this redacted information. Think about that. Donald Trump wants the public to have the redacted information, the threats, the death threats. He wants that in public. The court says there is little indication of a First Amendment right of access in this instance. To begin with, the court is unaware of any specific precedent or history for that right in the context of a motion seeking to restrict extrajudicial pretrial statements or to require notification before conducting a survey of the potential jury pool, much less the identifying information of potential witnesses embedded in those motions. So you see how thoughtful Judge Chutkan is there. It's really an honor that we have an honorable judge like Judge Chutkan, a prosecutor like Special Counsel Jack Smith calling out Donald Trump for his conduct here. You're seeing how the wheels of justice turn in the right direction, folks. Do me a favor, check out patreon.com/MeidasTouch for more. patreon.com/MeidasTouch. Spell MeidasTouch, MEIDASTOUCH. Take a look at that and go to MeidasTouch.com as well. Have a great day.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.